Welcome to Construction Law, lecture number 1, the importance of law. So what is the importance of law in construction? Why do we have an area of law designated to construction and construction disputes? Well, law in itself, it provides a degree of certainty and fairness in what otherwise would be chaos. If a person is harmed, they can rely on the laws to attempt to minimize the harm and make themselves whole. Areas of law in construction are criminal law to a small degree, but it's there, civil law, and administrative law. Are important in the construction setting to prevent, in large part, to prevent theft of money, theft of tools, theft of property, personal property, real property, the land that's being developed. A contractor, typically they're concerned about their tools being stolen, and that can happen quite a bit in California, in some areas of California. Criminal law supposedly helps contractors prevent theft of their tools. For a property owner, they may be afraid that if they build something, that a stronger person may take that property by force. That old saying that might makes right. Some stronger person or more determined, more violent person could take somebody else's property, if not for criminal laws. And because there are criminal laws, if somebody tries to take somebody else's property by force, hopefully they would go to jail for that and hopefully prison for that. But it still does happen from time to time. Criminal laws assist in preventing people from stealing property from one another. However, in California, stealing money from one another is typically delegated to civil law and in civil court. Frequently, when the property owner or even the contractor, they feel like the other party stole from them, they feel like that's theft. Theft is a crime. And so it's not uncommon for them to contact law enforcement and want the police to get involved. And what do the police usually say? Oh, you guys have a contract together? Well, I'm sorry, we can't help you. That's a civil matter. We can't help you out. So they'll tell the parties they need to go to civil court if they want to resolve their dispute. Nobody's going to get locked up. Civil matters. When a construction project breaks down, the parties frequently claim that they didn't get what they bargained for. The property owner may claim that the contractor took their money and ran. It's not uncommon for an owner to contact law enforcement and demand they arrest the contractor. However, the typical response by law enforcement is to say, "This sounds like a civil matter. We can't do anything." And then they hang up. Maybe they don't abruptly hang up, but that's the typical response. They don't get involved. If the parties have a contract together, well, then that's a contract dispute. And any money that changed hands, that was part of that contract. So it's a civil matter. It's not a criminal matter. The contractor may claim that the property owner didn't pay them enough for their hard work in improving the owner's property. That's frequently a common dispute when contractor will claim they didn't get paid enough for their hard work. They put their blood, sweat, and tears into a construction project, but they didn't get paid what they should have been paid. They already gave a low bid, and that's why they got the project. And even after giving the low bid, they still got taken advantage of. So they want more money, or they want to get paid for what they haven't been paid for. Civil courts in California, called superior courts, provides a dispute resolution process for civil disputes. Now, it is a extremely slow process. to resolve a dispute. Extremely slow process. It can take years to resolve a dispute in California Civil Court, Superior Court. But it's better than nothing, I guess. Cost of civil disputes. Litigating a matter in Superior Court is costly. Typically, taking a matter all the way through trial will cost each party at least $50,000 in attorney's fees, not including expert witness costs, which could be the same, if not greater, then court costs, process server fees, subpoenaed records fees, etc. There's a lot of costs involved in litigation. The financial difficulty in litigating disputes frequently results in matters not being litigated or a party settling the dispute, even if they believe they are in the right, solely to avoid the cost of litigating a matter. It can cost so much money in attorney's fees to litigate a matter that it's not uncommon for people to file a lawsuit in small claims court. Even if they're owed like $30,000, they might file a lawsuit in small claims court and only get up to $10,000 because that's the max in small claims court. They might do so because they know they'll never get their attorney's fees back. And if attorney's fees are like at least $20,000 to litigate a matter, and that's not even going through trial, then it might be more cost effective just to go to small claims court. And a lot of people actually do that. It's not uncommon to see people with civil disputes between $10,000 and $30,000, and they go to small claims court to resolve it rather than going to Superior Court. Litigating disputes also puts a strain on the superior courts in California. So the state legislature uses administrative agencies to reduce the burden on both the state superior courts, administrative law. In California, there are a number of administrative agencies that exist in part to prevent disputes from ever occurring. And if they do occur, to provide a streamlined, hopefully streamlined, and cost-efficient manner in resolving the dispute. Related to the construction industry, some of the administrative agencies include the Contractors State License Board, which is the acronym for that is the CSLB, Contractors State License Board. The Department of Labor Standards and Enforcement, DLSC, they deal with employees and frequently with employees that feel like they have not been paid the wages that are due to them by their employer. The Workers' Compensation Appeals Board, the acronym for that is the WCAB. They deal with workers' injuries. And the California Department of Insurance. They deal with issues related to insurance where a party feels like they were wrongfully denied on an insurance claim. They got a denial letter from an insurance company. Now they want to sue the insurance company for that denial. One of the first steps in going about that process is to contact the California Department of Insurance and get their take on the matter. And hopefully for the California Department of Insurance to resolve the matter. The most important for contractors is the Contractors State License Board, the CSLB. Contractors State License Board. The CSLB is an administrative agency in California that regulates contractors, enforces California construction law, and assists in resolving disputes involving contractors. The CSLB establishes minimum standards of competency in both the building trades and in understanding of construction law for new contractors. For new contractors, they have a test for both. They have a test for the trades and they have a test for the law related to contractors. They have different trade examinations for different specialties, for plumbing, electrical work, HVAC, concrete, carpentry, plumbing, general building, a whole bunch of different trade examinations. And it's 3.5-hour examination for that. Then they also have a law test, a law exam, which is also 3.5 hours, to show that the contractor has at least a minimum understanding of construction law. And it's designed, the law is designed to not only help the homeowners, the property owners, and the people that could possibly be harmed by the contractor, but it also helps the contractor themselves. It helps them in giving them a guide to follow to help them stay out of trouble and to help them to hopefully not be sued by somebody else. The Contractor State License Board, they conduct stings and sweeps of unlicensed contractors. They will periodically, and actually quite frequently, they will go to somebody's house and they will obviously get authorization to use that person's house. And they will invite unlicensed contractors to come to that house and offer bids for work. And once those unlicensed contractors come out, and once those unlicensed contractors give the property owner, whom they think to be the property owner, but is actually somebody who works for the CSLB or law enforcement, they give them an estimate and or a contract, then that unlicensed contractor will be arrested. So those stings and sweeps, they happen quite a bit in California, and they help to make sure that whoever's doing construction at least meets the minimum standards of competency in both the trades and the law. The CSLB provides a mediation and arbitration process free of charge to assist parties in resolving disputes involving licensed contractors. That is a really nice thing. I mean, there's a lot of great things about the CSLB and a lot of things that I appreciate about them very much. And this is definitely one of them, that they provide a mediation process. If a homeowner has a dispute with a contractor, they can go to CSLB arbitration, which is free. It's very informal. It's primarily just online and via the telephone, and via email. But it's a cheap, free process that the parties can attempt to resolve a dispute that they have. They can also go to CSLB arbitration. Private arbitration is really costly. It can cost tens of thousands of dollars for people to do private arbitration. But the CSLB arbitration is free, which is really nice for contractors and homeowners involved in construction disputes. It's free for any dispute up to $50,000. If there's a dispute up to $50,000 or around that amount, the parties can attempt CSLB arbitration if they both agree to it. Because it's free, the CSLB, they provide an arbitrator free of charge, and they also provide an expert free of charge. The expert could also be involved in the mediation process, where the CSLB expert will come out to a job site, a project site, review what was done, and give their take, their impression. Did what the contractor did or did not do, did the contractor meet the minimum standards of competency in their building trades? Did it meet code standards, whatever the contractor did, or did it not? And if it did not meet the code requirements, what's the cost to correct it? What should that contractor have to pay based on what is the homeowner going to have to pay, the property owner going to have to pay some other contractor to complete the work? A nice thing about that for contractors, that whole process, is that that expert is an expert, and that expert is free, and the arbitrator is free, and they're both experienced in construction law. They both probably have a background in construction law or construction work in itself, and sometimes that can be pretty beneficial to the contractor, because any damages that the property owner is awarded, any money damages that the property owner is awarded, it's probably going to be a lot less through CSLB arbitration rather than if they go to regular superior court. Most contractors that comply with the CSLB rules and regulations rarely, if ever, must litigate a matter in superior court. If somebody has a good understanding, if the contractor has a good understanding of the construction laws, and they follow those laws, then it's unlikely that they will get into trouble or that they will get sued. If they are going to get sued, it's probably because of an accident, not anything intentionally wrong that the contractor did. They did something negligent and accidental, which is hopefully covered by their commercial general liability insurance. For example, I was a contractor I did construction work for approximately 15 years. Even if after I became a licensed attorney, I still did construction work on the side because it paid so much better than being an associate at a law firm. And all in those 15 years of being a general building contractor, I got sued 0 times. Never sued anybody, never got sued. I did sue an insurance company, but that was not related to construction at all. So I never, I was, for my time as a contractor, I was never sued and I never had to sue anybody. Why? Because in large part, I was following the CSLB rules as best I possibly could. And complying with the rules, following the rules, doing written contracts, invoicing my clients in the way that the CSLB wants them invoiced, getting building permits, when having employees having workers' comp, hiring licensed subcontractors, doing what you're supposed to be doing, and that way you stay out of trouble. Laws. Where do the rules and regulations come from, and how are they enforced? Both the United States and California Constitution establish how laws are to be enacted, enforced, and interpreted. The legislative branch of the government, and for the US, that's Congress, also state Congress, enact the rules that they want its citizens to follow. The legislative branch of government enact the rules they want its citizens to follow. The executive branch enforces the rules created by the legislative branch. So the executive branch in the state of California, that would be the governor of the state of California. For the United States, that would be the president of the United States and everybody who works for the president or underneath the president. The judicial branch interprets the rules if there is a disagreement over how a law should be applied to a certain set of facts. If there is a conflict between a state law and a federal law, typically the state law is preempted by the conflicting federal law. The federal law trumps the state law most of the time. So the judicial branch is the judges. That's the state superior courts, federal courts. That is the judicial branch. Courts. A litigated construction claim, civil dispute, may be heard in state superior court, or if one party is from another state, then the matter may be heard in federal court. So in federal court, for construction disputes, you can only go to federal court if there is diversity of citizenship, meaning one party is from, say, California, and the other party is, say, from Nevada or Utah or Oregon. One party would have to be from a different state. Now, they can be from different states and still sue each other in state superior court, but it might be more beneficial for the person who's out of state to have the matter litigated in federal court because they might feel like they won't get a fair shake in state superior court. It's debatable, but they do have the option of going to federal court. If they're from another state, they can litigate the matter in federal court instead of state court. To start the litigation process, the plaintiff, the party alleging to have been harmed, they file a complaint in Superior Court in the county in which the property involved in the dispute is located, or in the county in which the defendant resides. That's called the venue. The venue is the county in which they filed the lawsuit. What Superior Court? The Superior Court in what county in which they filed the lawsuit. The defendant is the party alleged to have caused the plaintiff's harm. The plaintiff says that defendant, they caused me harm. They're liable for the harm they caused me, and I want my money. I want reimbursement for the harm they caused me. If the plaintiff files a complaint in the wrong county, the wrong venue, then the matter may be moved to the correct county upon motion of the defendant to change the venue. Now, the defendant doesn't have to change the venue, but they can if they want to. Maybe there's a good reason not to. Maybe it's easier for them to litigate the matter in one venue and one county rather than another county. So, but if the plaintiff technically should have filed in a different county, then the parties might attempt to get it relocated to the proper courthouse. Statute of limitations. You can't just wait forever to file a lawsuit. You can't wait 20 years to file a lawsuit. There is what's called the statute of limitations. A lawsuit, if filed, must be filed within a certain amount of time after a plaintiff has been harmed, or the plaintiff may have waived their rights due to their own procrastination. You wait too long, you might lose your rights to file a lawsuit. In most construction disputes, the parties have 4 years to sue each other based upon breach of a written construction contract. In California, that is explained in California Code of Civil Procedure, Section 337, discusses breach of a written contract. A homeowner has 4 years to sue a contractor based upon patent defects of the contractor's work. That is Code of Civil Procedure, Section 337.1. So in most cases, and regarding property damage, where the contractor damaged somebody's property, there is a 3-year statute of limitations to negligent acts that cause damage to somebody's property. But for defects to a person's house, patent defects, the homeowner has up to 4 years to sue the contractor. There are some situations in which the homeowner may have 10 years to file a lawsuit, but those are rare situations involving latent, hidden defects. But there's certain hoops and requirements that the homeowner must meet before they file a lawsuit beyond 4 years and up to 10 years. However, for some causes of action, that time is actually drastically reduced, such as a contractor's foreclosure action based upon a mechanics lien, in which the contractor only has 90 days to file the lawsuit if the lien is not paid off. They have, after a project is completed or a contractor is terminated, they have 90 days to file a mechanics lien. They only have 90 days to file a mechanics lien. If they want to file a mechanics lien, they only have 90 days. They can up to 4 years for breach of contract, but only 90 days to file a mechanics lien. And then after they file the mechanics lien, they only have 90 more days to file the lawsuit. File the lawsuit based upon the mechanics lien. And if they wait too long, their mechanics lien is void. It has no bearing, no weight. It's worthless. Not only is it worthless, they can get sued if they don't release the lien. They have 90 days after project is completed to file a mechanics lien if they're not paid, and only 90 days after that to file the lawsuit if they're still not paid. Summons and complaint. So one party, the plaintiff wants to sue a defendant. How do they do that? Well, they fill out a summons and complaint, and they file the summons and complaint in superior court. The complaint must describe at least the minimal requirements as to why the defendant caused the plaintiff's harm. These minimal requirements for the causes of action can be found in the California Civil Jury Instructions, also known as CACI, California Civil Jury Instructions, which are available from the state court for free in a PDF format. Typical causes of action in construction include breach of contract. Usually that's going to be a breach of written contract, but you could also have a breach of an oral contract. Negligence, those are basically accidents. Breach of warranty. Contractor usually has warranties that he provides not only by contract, but by statutes, and implied that their work is going to be basically functional. Whatever they build, it's gonna be useful for its intended purpose. And if it's not, that's considered to be a breach of warranty. Also, foreclosure on a mechanics lien, that's going to be filed by the contractor, not a property owner. And quantum meruit. Quantum meruit is basically a time and material basis for recovery. I did all this work. If you say there's something wrong with our contract, well, then I should at least be paid based on the value of the work that I actually did perform. The value of the work and the value of the materials that I put into the homeowner's property. The defendant must be served with both the summons and the complaint. The summons notifies the defendant that they are being sued, and they must respond to the lawsuit to avoid waiving their right to present a defense. If they wait too long to present a defense, then they waive a right to defend against the lawsuit. And the judge may decide, you know what, you waited too long. You waited more than 6 months to respond to this lawsuit. So you know what? I'm just going to rule in favor of the plaintiff. Maybe you do have a good defense, but you waited too long. So should have been quicker. Dismissal. Dismissal is somebody filed a lawsuit, but the lawsuit gets dismissed. If there is a defect with a complaint, then the defendant may file a demur and/or a motion to strike. Those are constant threats by the defendant's attorney. They receive a lawsuit and they said, hey, you know what? I just had this potential new client come in here, and I think you're going to have to withdraw this lawsuit. You're going to have to file a request for dismissal. If you don't, I'm going to have to file a demur and/or a motion to strike. Now they say that a lot. That gets thrown out there a lot. But the amount of times that they actually do file a demur or motion to strike is rare, or not as common. And the amount of times those demurs and motions to strike are actually upheld, that's even rarer. But it does happen. A demur is the defendant asking the court to dismiss the plaintiff's lawsuit because the complaint does not meet the minimum requirements establishing the plaintiff's right to sue, and or a basis upon which they filed the lawsuit. Frequently, a demur is filed in construction disputes when an unlicensed contractor files a lawsuit based upon breach of contract, in which case the judge will probably dismiss the lawsuit. So in California, for a contractor to file a lawsuit, they have to be licensed. They have to be licensed by the Contractors State License Board. And if they are not licensed, their complaint will be thrown out. I had a case like that in which contractors sued my client. My client's the property owner. I looked at the lawsuit, and the contractor did not include a license number. Did a license check with him on the Contractors State License Board, and sure enough, nothing popped up. No showing that he had a license. Reached out to the opposing party. I'm like, hey, does your client actually have a contractor's license? He didn't. And so I said, well, you know what? I'm going to have to file a demur then, because contractor without a license cannot sue in California, cannot sue for breach of contract in California. There was a lot of huffing and puffing, but eventually, before it got to the demur hearing, the contractor's attorney did, in fact, withdraw the lawsuit. A demur and/or a motion to strike may be approved when a contractor files a foreclosure based upon a mechanics lien after the 90 days to file the suit expired. So the contractor filed the lawsuit. Maybe the contractor was appropriately licensed, but they filed the lawsuit based upon a mechanics lien. But after the time to file the lawsuit had expired, and maybe after the time to file a mechanics lien had expired, or maybe after the time to file the lawsuit based upon a mechanics lien had expired. But regardless, they were too late. And because they were too late, they cannot proceed on their foreclosure action, in which case that part of the complaint would most likely be stricken from it. Discovery. Okay, so maybe there's nothing wrong with the complaint. There's nothing wrong with the answer. The answer is filed. And then you go on to discovery. If there is no defect with the plaintiff's complaint, then the defendant files an answer to the complaint. The answer states that they are providing a defense. The answer says, you know, okay, I'm not gonna countersue, or maybe you do, but there I have a valid basis for not just bending over and agreeing with whatever the plaintiff says. There's a good excuse for me not complying or doing what the plaintiff is demanding that I do or should have done. After that, the parties start the discovery process. Types of discovery include written demands for responses. Those are called requests for admissions, requesting that the other party admits to certain facts, form interrogatories and special interrogatories, asking specific questions to help in the discovery process, and basic facts about the other party. Where were they born? How old are they? Where do they live? Who's their employer? Was there anything wrong with the contract? What was the contract? Then you can do a request for production of documents. You have the other party produce the contract, the building permit records, any other applicable records and photographs and information related to the case. After that, or maybe even before that, you could do depositions. Those are basically interrogations of the other party or special people related to the case. You basically have the attorneys interrogate somebody, get it down, written down by a court reporter, and that may or may not be used as evidence during trial. Usually to attack the credibility of somebody giving testimony for something they said at the deposition that's different from what they may have said or are saying at trial. Subpoena of records. Subpoena of records are pretty common. That's where you're looking for records from the Contractors State License Board, maybe from the building department, from other subcontractors and suppliers. What really happened? What really happened on this project? What did everybody actually really do? Trying to look for those unbiased opinions, not the biased opinion of the opposing party, but third parties. What do they say about really happened? Expert witnesses might have special investigators, other contractors, former contractors, home inspectors, come out to the job site, the project site, look at what was actually done. Is any of this work defective? How long should this work really have taken? Site inspections occur. All right, next, parties demand discovery so they know what the other side is going to produce and say at trial. If you know what somebody's going to say, if you have the testimony of what somebody said during a deposition, you have a pretty good idea of what they'll be saying at trial. nice thing about the discovery process is if both sides are represented by reasonable counsel and efficient counsel, and the parties themselves are reasonable and listen to their counsel, then you really should resolve lawsuits before they get to trial. And the vast majority of lawsuits do end in settlement. They reach a settlement. The cases get dismissed after the settlement money is paid out. They get dismissed long before trials because you have two competent attorneys on each side, and if they have reasonable clients, the matter should resolve prior to trial, because the attorney should know what the outcome is going to be if you go to trial, or have a really good idea of what the outcome should most likely be if the matter proceeds to trial. Of course, there's never ever a guarantee of what's going to happen at trial and how a judge and jury will decide, but the attorney should have a basic understanding and a legitimate reason as to why they are recommending settlement and why a settlement should be reached. Parties subpoena records from the building department, the CSLB, subcontractors to determine unbiased facts as to what occurred on a project. Dismissal, motion for summary judgment. Okay, you go through the discovery process, and then typically the defendant might say, hey, you know what, plaintiff, you didn't meet your burden. You didn't establish the necessary facts. You didn't produce the necessary evidence to support your lawsuit. So I'm going to file a motion for summary judgment. I'm going to ask the judge to say, to rule and to opine that you did not meet your burden. So the case should be dismissed. A complaint may also be dismissed. A case may also be dismissed by a motion for summary judgment, typically filed by the defendant after an answer by the defendant has been filed. The parties have gone through the discovery process, and the defendant, through discovery, has realized that the plaintiff cannot meet a key element of a cause of action. For example, if it was discovered that the plaintiff contractor's license was suspended while working on the defendant's property, they got the CSLB records from the CSLB, they got a history of the contractor's license, and they were like, hey, wait a minute, this contractor was suspended. His license was suspended while he was working on my project. If that occurs, the defendant owner will argue that the plaintiff contractor's breach of contract claim is prevented. It's prevented by the lack of having a valid contractor's license throughout the duration of the project. A contractor must be licensed in order to file a lawsuit based upon breach of contract, or his lawsuit is void by operation of law. That is found in Business and Professions Code 7031. Now, the contractor might argue he was substantially compliant with the licensing laws, and maybe he was, and that might be up to the judge to determine, was the contractor actually substantially compliant with the licensing laws? Was it just a clerical error that his license was temporarily suspended? Or was it actually because the contractor wasn't paying his bills, wasn't paying his workers' comp, and that's why his license was suspended? Courts. If litigated, the matter is filed in state superior court, which is the trial court. Over 95% of civil suits settle prior to a trial. As in part, trials greatly increase the cost to all involved. Attorneys are not cheap. The prevailing party is only entitled to reimbursement of their attorney's fees if stated so in the party's contract, or if an applicable statute allows for attorney's fees. In most construction matters, attorney's fees are not going to be granted unless there is a specific statute that grants them. If it's stated in the contract between the parties that the prevailing party is entitled to attorney's fees, then they can get attorney's fees. Otherwise, generally not. If the contractor is unlicensed, then the homeowner might be able to recover attorney's fees. But if a contractor sues based on a mechanics lien and there's no attorney's fees clause in the contract, then he's not going to get reimbursed for his attorney's fees. Subcontractors, however, by statute, they can get attorney's fees if they sue a contractor for non-payment. If a contractor owes them money, by statute, they can get reasonable attorney's fees if they file a lawsuit against the contractor. In contrast, if the subcontractor files a mechanics lien against the property owner because the subcontractor was not paid by the prime contractor, the prime contractor is the one who had the contract with the homeowner, but the subcontractor does not have a contract with the homeowner. The subcontractor cannot get reimbursed for attorney's fees with a foreclosure action on a mechanics lien. However, if the sub sues the prime, they could get reimbursed for their attorney's fees. If the matter does proceed to a trial, then the judge or jury will reach a decision, and a judgment is entered by the judge. Once a judgment is entered by the court, then the losing party may appeal the decision. However, there is a limited time to file an appeal. They have a very short window in which they can file an appeal. A lot of people, if they lose, they're like, I'm going to appeal this. I'm going to take this all the way to the Supreme Court. Well, that's really costly. And you got to really be certain that the judge screwed up in his application of a law. If the judge screwed up in the interpretation of facts, that's not appealable. It has to be a misinterpretation of the law or misapplying the law to the facts. But it can only be based on the law, not the facts, for an appeal. An appeal is heard in state circuit court. If a party loses an appeal, they may proceed to state Supreme Court. It is at the Supreme Court's discretion as to if they will review a matter or not. They don't have to review every case that is appealed. They can just review what they want to review and not review what they don't want to review. It's because court is so costly, it's a good practice to try and avoid court as much as possible. Some people really like going to court. They really like suing people. They get something out of it. Well, I don't know, but they get something out of it. But it's generally a much better practice to stay out of court as much as possible. The best way for contractors to avoid court is by following the rules established and enforced by the California Contractors State License Board. By being licensed, the contractor preserves the right to file a lawsuit if necessary. So, one, make sure you're licensed. By having written contracts, the contractor establishes the party's rights and obligations in a clear and simple way to follow. Contracts should be very clear and very simple. Not complicated, not full of legalese, but you want it to be very clear and simple so that anybody who reads it can understand it. For prime contracts, the rules are found in Business and Professions Code 7164. They don't have a lot of requirements for prime building contracts. Prime building contracts like commercial contracts, new residential structures, new projects, those are prime contracts. And you find the rules in Business and Professions Code 7164. Doesn't have a lot of rules, just a few. Then for home improvement contracts, those are found in Business and Professions Code 7159. And home improvement contracts do have a lot of rules that the contractor has to comply with. Thankfully, you can get all those rules straight from that statute, 7159, and contractors frequently they will just put in the basic information about a contract that they need to have in there, and they just copy and paste 7159. They copy it and then they just paste it into their contract. And as long as it covers everything that they need to cover, then they're most likely compliant with the licensing laws as to their contract. By only working on projects with building permits, the contractor provides, by only working on projects with building permits, the contractor provides a clear public record as to meeting the minimum building requirements. So one, they're licensed, which is public record. Two, they have a written contract, which is signed by both parties. That's pretty clear and convincing evidence as to what the parties are supposed to do, their rights and obligations. Then three, getting the building permits for the project. If a building permit is required, the contractor should definitely get it. A lot of contractors, they don't like getting the building permits. A lot of homeowners don't like getting the building permits because they know it will drag, it will slow down the process of construction, and it does slow it down. But in so doing, it creates a clear public record about what really happened on a project. And just the job inspection card, it's a one-page document. The building department records, the permit details might just be like 10 pages. That's a lot clearer than having to review hundreds of pages and hundreds of photographs as to what occurred. Instead, you can just look at the permit records, which are very concise and reviewed by experts in the construction industry. 4, by having workers' compensation insurance, the contractor protects his or her employees and also preserves the contractor's rights to file a lawsuit against a non-paying property owner. If a contractor has employees but they don't have workers' comp, then they lose their ability to file a lawsuit against somebody. And they expose themselves to disgorgement of all the money they've been paid by a property owner if they don't have workers' comp. Why? Because the state really wants the employers to have workers' comp. They want to make sure that if an employee is injured, that employee is going to be taken care of by the employer's workers' compensation carrier. Also, not required, but a really good idea to have commercial general liability insurance. If the contractor has commercial general liability insurance, the contractor protects themselves if sued for any accidents that occur on a project, any accidents that injure somebody who's not a worker or destroys the property of the property owner or a neighbor. That should be covered by commercial general liability insurance. All right, so that is the end of the first lecture, and thank you very much for attending. And I will have the second lecture out for you shortly. All right, thank you very much.